Hello, welcome to this mini lecture on International Paper versus Ouellette. This is to be viewed in conjunction with the mini lecture on AEP versus Connecticut and a broader discussion about the continuing relevance of the common law within the context of the modern environmental statutory regulatory system. Both IP versus Ouellette and AEP deal with the statutory systems of water pollution and air pollution. I'm going to go ahead and share my slide here to provide a little bit of background context. As I mentioned, these public nuisance doctrines and other common law doctrines remain operative as fallbacks or gap filler principles when the statutory system has not addressed a particular environmental issue. Now, one other brief review note here, and that is public nuisance doctrine itself. We've talked about this in prior lectures, but just as a reminder, public nuisance is essentially the unreasonable interference with the right common to the general public. This comes directly from the restatement. One of the important things to remember is that there is no property right involved, unlike with private nuisance. And as I've said previously, it's unfortunate that these two doctrines use the same terminological reference to nuisance. Public nuisance is a very broad principle or doctrine that includes broad set of interest under public health, public safety, public peace, comfort, and convenience, as well as conduct prescribed by statute, ordinance, or administrative regulation. And the way the doctrine has sought to limit courts being overwhelmed essentially by this very broad claim is to restrict who can bring a public nuisance claim, mostly government agencies, but also groups of people or individuals who are specially affected. I won't go through all the limitations here, but just by way of quick review. So you see this is a very broad doctrine. Now the case here that I'm looking at is International Paper versus Ouellette. The question that was addressed was whether state public nuisance doctrine remained effective or operative after the enactment of the Clean Water Act. That is to be distinguished by an issue that earlier cases addressed, specifically City of Milwaukee versus Illinois, focusing on the question of whether federal public nuisance common law doctrine survived the enactment of the Clean Water Act. And under City of Milwaukee versus Illinois, the conclusion was that federal public nuisance claims did not continue. International Paper then addressed an issue that had been left unresolved, and that is the question of state public nuisance claims. Now, the facts in International Paper were relatively straightforward, involved a claim by a plaintiff in Vermont against International Paper, a company that operated a plant in the state of New York. These were located both on Lake Champlain. For those of you who are not familiar with the geography, Lake Champlain serves as the boundary between the state of Vermont and New York. It's an elongated lake that crosses over into Canada. And so just across from the state border in New York was the International Paper plant. Harmel Ouellette, the plaintiff, was bothered by the odors coming from the water pollution, International Paper's water pollution, and together with over 100 of other property owners filed a public nuisance claim in Vermont State Court. The claim was removed to federal court, and eventually the Supreme Court found that the public nuisance claim was preempted by the Clean Water Act. International Paper initially argued broadly that state public nuisance claims were preempted and no longer existed, just as the federal public nuisance claims had been displaced or supplanted by the Clean Water Act. Note here one quick thing in that under City of Milwaukee, the federal common law claims were displaced or supplanted by superior congressional statute, the Clean Water Act. In Ouellette, the issue is not of displacement, but rather of preemption, because we have the question of whether federal law generally, and that is the Clean Water Act, is supreme over state law, state common law. Right? So a small distinction here, but it's just important to keep in mind. And the main reasoning here by the Supreme Court was that allowing a state public nuisance claim to go forward in the state of Vermont would upset the Clean Water Act scheme, in that would essentially allow permits issued in the state of New York to be overridden by making it more difficult for international paper to operate. It upset the balance that the state permitting agency in New York would have struck between burdens on the polluter and the effects on pollution affected population. The Supreme Court specifically indicated that Ouellette would be free to sue in the pollution generating state, that is in New York. And there, the calculus was slightly different in the view of the Supreme Court, in that the permitting agency there, the state of New York, would be able to properly engage in the balancing, as I've just mentioned, and therefore would be more appropriate for that particular state to address the claims by Ouellette. Note here, by the way, that the Supreme Court also indicated that under the Clean Water Act scheme, a state could always impose stricter requirements than the federal Clean Water Act requirements. Right? So that is essentially the outcome. State public nuisance law in the recipient state is preempted, but in the pollution generating state remains available to pollution victims. Just a quick summary slide here. As I mentioned, federal public nuisance law under Milwaukee versus Illinois is displaced. That applies to both waters within the United States that are subject to the jurisdiction of the federal government under the Clean Water Act, as well as ocean waters that are subject to jurisdiction of the federal government, of pollution that is subject to the jurisdiction under the Ocean Dumping Act. State common law nuisance is preempted in the pollution recipient state, but not in the pollution generating state. The Clean Water Act does not contain a private right of action. There is no implied right of action under the statutory scheme of the Clean Water Act, so there's no separate ability to sue other than the Section 505 citizen suit provision. And then finally, there is still a tort claim for economic damages and punitive damages that survive the enactment of the Clean Water Act. Okay? So I'll leave it there and see you in the next mini lecture.